Greetings. This is attorney Della Welch, and this will be tape 2 of workers' compensation law in California. If you read the California Labor Code, you'll learn about workers' compensation law. We're talking about terms. They often say that workers' comp is a lot of vegetable soup with all of this, like alphabet soup, with all these letters of the alphabet. One important term is PNS, permanent and stationary. It's also called maximum medical improvement. That's where you've been healing from your work injury, and your injuries have gotten to the point of healing where you're really not going to get any significantly better, and your permanent disability can be rated, and you can see the value of your case. Another term you need to know is QIW, which is Qualified Injured Worker. I had a case where someone had a very high position, and the doctor made them QIW, or a Qualified Injured Worker. That meant that they were going to lose their high-paying job. And so we did the deposition, and the other side was trying to make it so that the person was not QIW, that he didn't have to leave that high-paying job. Now, there's various ways. There's 3 different ways that a workers' compensation case will be resolved. One is CNR, or compromise and release. That's an agreement whereby you look at the value of the permanent disability, you look at what the treatment would cost, you look at the whole value, the age of the person, and the insurance company at this point, they want to buy out the value of the case and give you your money right now and have no further future medical treatment to pay. So they may say, this case is worth $50,000, $100,000, and you may say, oh, I'd like to take a trip to Hawaii. So you want to take your money right now. But be careful and make sure you're going to be able to handle any future medical treatment from your work-related injury. So the second way is by a stipulation. Once the medical reports come back and the reports are rated based on the formula that the raters use, then the agreement you can stipulate, and that's a stipulation, and that does give you future medical treatment. And if it rates 70%, that's a life pension. Going back to the CNR, where you don't get future medical treatment, what they often ask for, the employer, is a resignation. So you get a sum of money, but the bad news is you're losing your job. And then an F&A is a finding and award. That's a decision made by the workers' compensation appeals judge. And what he does is listen to the testimony of the employer, the employee, read the medical reports and go through all the evidence, and then make a decision based on all of the evidence. I had an interesting case where I offered $40,000 to resolve a case. I had authority from the employer for that amount. And what happened is the people rejected that. I offered $40,000 because this was a potential case where a person could get $2 million award. But what happened, we went through the trial and I cross-examined this person, and he testified he'd never taken the ibuprofen that the doctor said caused the kidney failure. And so based on my cross-examination, I got to take nothing, which is very hard in workers' comp. Then the other attorney said to me, okay, we'll take the $40,000. Well, that was too late because we'd already won in that case. So that's an example of the risk you take when you go to trial. There's also surveillance. I had one case where a person said they were so stressed out they could only drive with a teddy bear. Well, the thing they didn't know is I had films of her driving all over without the teddy bear. So I was able to show them the films, and the case settled very fast. Also, there's the term QME. That's a qualified medical examiner. This is a qualified physician that is certified by the Workers' Compensation Appeals Board in order to examine injured workers. There's also the term AME. All of these terms are like vegetable alphabet soup. They start with all the letters of the alphabet. AME is agreed medical examiner. That's where on certain cases the parties agree that this particular doctor is a very neutral doctor and will give a very good opinion that'll be easy to follow and that will be able to be rated by the board and be substantial evidence. There's also the case of Green versus WCAB that gives great emphasis to the agreed medical examiner. I had one case in which the parties had agreed to an agreed medical examiner who was a very prominent doctor with great credibility. And the presumption under the Green case was in favor of the agreed medical examiner. But in cross-examining the doctor, I asked him if he'd ever treated a Crohn's case before, and he said he had not, and therefore I was able to show that he really didn't have substantial evidence in his report because he wasn't qualified to be an agreed medical examiner. I asked one doctor if he had ever written that there's insufficient evidence that Crohn's disease is aggravated by stress. And he said, no, only a fool would say that. Well, I luckily had the article to impeach him to show that he had written that article. And that's the part of the preparation a defense attorney uses in order to do the deposition of an agreed medical examiner. WCAB is Workers' Compensation Appeals Board. And I mentioned earlier there's one in downtown LA, in Van Nuys, in Pomona. You can check your local area. These are administrative offices, administrative courts, and the judge makes decisions, or a compromise and release can be submitted, or a stipulation. WCJ stands for Workers' Compensation Judge. These are judges who make a finding and award. RECON, R-E-C-O-N, that's a type of appeal. If you get a decision from the judge and you don't like it, you have a certain amount of days, only 20 days, to appeal or by filing a petition for reconsideration and see if the decision can be turned around. If not, if you lose at that level, what you can do is file a petition or a writ, and this is filed at the Court of Appeal level, and it's kind of hard to take a case beyond the Court of Appeal level if you don't like it to the California Supreme Court.